It's extremely more serious. It's extremely more serious. We've had people with OW1s who have killed people, or OWI2s who have killed people or significantly injured somebody. You're just so super very lucky that no one was injured and no one was hurt. It's a weird thing that here in Wisconsin, our OWI first is a ticket, a forfeiture. That's it. It's just weird and not necessarily in the state's best interest, but that's where we are. But when you're getting up to these high offenses, it's not only more serious, it's absurd. It's crazy. We shouldn't even have to have people with OWIs this high. I do understand that you want to change, you're trying to change. You're 58 years old. You should have figured that out by now for a better path. And you have to, otherwise somebody could die. God forbid, an innocent person. I think that you are a risk to our community, and it's shown just in this offense alone and that conviction. But hopefully you're going to stay in Minnesota. Even after you're released in Wisconsin, don't come back. Okay, I'm just gonna warn you right now, don't come back to Burnett. I don't want my community at risk. For the most part, the agreement does make sense. And I understand the reasoning behind it. You are accepting responsibility right away, but you don't want to be punished more. You want the good old deal of serving the times together. But they're two separate incidents, two separate states, two separate dates, two separate times you drank intoxicating beverages beyond the legal limit and put people at risk. Two separate, all the things. So I just can't see that this is something that should be sat concurrently. But I don't know if it matters if I do it concurrent. You're going to be able to get out of Minnesota early with some types of programs, but again, you're not getting out. You're going to come to Wisconsin, you're going to sit your time, you're going to have a sentence. So you want to get out of Minnesota prison earlier, that's fine, but you're going to head on over to Wisconsin prison. With regards to this matter, the court does believe it is far more serious than 3 years in, 3 years out, concurrent. So what the court is going to do is I'm going to sentence you to 4 years initial confinement, 5 years extended supervision. You need more oversight on the end, and that means 5 additional years that can hang over your head, and you can sit more time in prison in Wisconsin if you do violate and you get revoked and sent back to prison. Very good reason to try and figure things out and go to the rehabilitation and treatment place. Because again, the next time you could have a life sentence because you could have killed a mom and 2 kids. The court is going to assess $5,523 in fines and fees plus a $10 blood draw fee. And even then you're getting the benefit of the doubt. I'm only using the fines and fees for the 4th offense. Simply because I'm going to tell you it's so hard to calculate and you're not going to pay it anyway. My gut's telling me that you don't have the money to pay it off anyway. The court is going to order, while incarcerated, you must make payments and it will be collected as a percentage from the Department of Corrections to be determined as reasonable by them while you are in prison and on extended supervision. They will collect these funds. This is a felony, no use or possession of firearm for life, no voting in any election until your civil rights are restored. The court is going to order absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. No alcohol, no bars, taverns, liquor stores, casinos, or any establishment that has the primary purpose for the sale or the service of alcohol. Court is going to order gainful employment because you're still going to be at an age where you can work. I know 75 or 80-year-olds that still work. Has told you that there is a mandatory minimum here, no early release, 3 years, mandatory. And you understand that?
Yes, I do.
And so if you're out early from Minnesota, but even if I figure the 46 months, let's just say you sit the full 46 months, but at 2/3, that would only be 2.5 years of incarceration. You would still need to come over to Wisconsin to serve the rest of your sentence. Do you understand that?
Yes.
Okay. All right. So, Mr. Ronning, I've read the memorandum. I've heard the arguments of both sides. I've heard your criminal history. You haven't had an OWI or DWI, as Minnesota calls it, since 2016, since you received ours. And then immediately thereafter, you received one in Olmsted, Minnesota. So 2 back-to-back. That makes it more serious. Had it only been 2016 until now, the 10-year gap, it could have been looked at as something different versus you were charged with this offense here, and then you were charged and convicted of another offense right after you were charged with ours. Operating while intoxicated is a serious offense, whether it's the first, the second, the third, but when you're getting up to 7, 8, or 9, I'm going to tell you, when you're getting up that high, and I'm going to say 10, whew, you may have a lifetime sentence there. It may be the maximum possible penalty that somebody can sentence you wherever it is, because 7, 8, or 9 is saying you have an issue, you have a problem, and your problem is, and I'm going to tell you, your problem is you have a substance abuse disorder, but your problem is the substance abuse disorder. You drink the alcohol, you drive. That's your problem. You drive. That's your problem. You drive. Now, have you had a substance abuse problem and you want to drink yourself until your liver fails? Good, great, grand. That's up to you. That's your choice. You get behind a wheel, you drive. That's your problem. That's a crime. And that's why we have 7, 8, or 9 and whatever you were charged with in Olmsted. Testing, regular alcohol testing. I'm also going to order something as thinking for a change or breaking barriers. There needs to be something there to help change that mindset. And I'm ordering an alcohol and other drug assessment and to follow all recommendations. You cannot be released from any supervision until all of those recommendations are complete. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is going to order that if you fail to pay your fines and fees, not only will a civil judgment be entered against you, you're always going to owe it, but the court will issue a warrant and you could sit up to 6 months in jail. I need to order your DNA. The jail will make sure that we have that. This is not a crime in which you can have your DNA expunged. I think that covers everything, Mr. Schmidt.
Did the court make a finding on eligibility for SAP or ERP?
The court will make you eligible for early incarceration only after it has been shown that you have had 3 complete and full years in custody. No release earlier than that. And that can be calculated using time in Minnesota, including time in Wisconsin. But you must sit 3 full years before you're eligible for any earned release programming.
Second, is the court ordering it concurrent or consecutive?
I said concurrent.
Third, did the court order a revocation of his license?
The court will revoke, oh, yeah, I haven't gotten to that yet. They still have to order OWI assessment and follow through. I did order an AODA. I also have to revoke your license, and a revocation here. Up to DOT, but what are you asking the court to revoke? How long?
Trying to find what it is from the court. I know DOT is going to revoke it for life.
They will. I can look at my big old binder. Try and find that as well.
I apologize for not looking that up before court.
Well, just has to be on the record. So the court is going to order. I'm going to order 10 years revocation of driver's license. 10 years ignition interlock device. Oh, I can look at this right now. Here we go. Nope, all it says is holy guacamole.
I think it might be 4.
It is not. It's revocation of 2 to 3 years, I think. That's silly to me. 3 years of revocation of driver's license, 3 years of ignition interlock device. Holy guacamole. I can't believe that that has even ever been part of, should be a whole lot more than that. But your license most likely is going to be revoked from the Department of Motor Vehicles, the DMV. They'll figure that out. What else?
That's all from me.
Mr. McLaughlin.
Your Honor, I just want the court to make the finding, as I believe you already have, that because Mr. Ronning was under an existing executed Minnesota sentence at the time, that he therefore is not entitled to sentence credit in this case, and that's a part of our record.
That there's no sentence credit for here?
Yes.
Yes, there's no sentence credit for here.
And therefore, Your Honor, because the court has, Mr. Ronning understands that you've gone above the joint recommendation, but because you have recommended it concurrent, Mr. Ronning has told me, has given me authority to say that he is not at this time dissatisfied with the court's ruling. However, and I appreciate his accepting, I think that shows again his acceptance of responsibility. However, he has 20 days from today's date to change his mind. Should he do so, he has the right to, within that time period, to seek relief to the Wisconsin Intermediate Court of Appeals. Services of his attorney continue in that time. Thank you.
Thank you. Mr. Ronning, just so I can be clear with you why I didn't follow the recommendation as it was recommended to the court. Again, it's because it's different dates, different times when you could have decided not to drive in different states. So there should be a different sentence, which means it should be something that would be more of a punishment because it was twice, 2 different times. All right, thank you. We are adjourned.
You didn't do badly.
No,
Thank you, Ms. Molsom. I think
You've only got
that
like another
covers your
year for-
services today.
That's not bad at all.
no.
Good luck, sir.
Thank you.
You're most welcome. Wasn't me.
Well, I've heard of that case.
I didn't have, that's not mine.
All right. We will call the case 26 CF 10, State of Wisconsin versus Stephen Ronning. The state appears through District Attorney Kevin Schmidt in person. Mr. Ronning appears in person in custody with his counsel, James McLaughlin. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. McLaughlin, can you recite it for the record?
Yes, you're right. My understanding is that Mr. Ronning will be pleading guilty to count 1 in the information operating a motor vehicle while under the influence, 7th, 8th, or 9th offense. Count 2 will be dismissed and read in for sentencing purposes. My understanding is that both parties will be making the same recommendation that the defendant be sentenced to 3 years incarceration in the Wisconsin State Prison System, but the sentence with any resulting extended supervision. The defendant, this sentence is recommended to the court to be run concurrent with his existing Minnesota sentence that he's serving in Olmsted County, or sentence out of Olmsted County. He's currently has been transferred here from the Minnesota prison system. Further, Your Honor, I did not discuss this raise this explicitly with the district attorney, but I would be asking the court to make Mr. Ronning eligible for the extended supervision program as part of this sentence. Because he was held without bond, I do not believe therefore he is entitled to credit, according to my understanding of Wisconsin sentencing statute.
Okay.
And as the court notes, as part of the defense sentencing for the court's consideration, the defense did submit a sentencing memorandum by my client service specialist, Miranda McClevey, on Mr. Ronning's behalf.
Yep, it's red, it's marked.
Thank you.
What do you mean by extended supervision program?
If he serves or if he has to serve any part of his sentence in the Wisconsin system and becomes earned release eligible, if there is any balance of his sentence that's left to be served, it would be converted to extended supervision.
You mean ERP-SAP, right?
Yes.
Okay, sorry.
That's what I mean by that.
But if and only if he sat completely day for day, the mandatory minimum.
Correct.
Okay. I have in front of me, Mr. Ronning, a plea questionnaire waiver of rights form along with the jury instructions as it relates to this offense. Did your attorney go over these documents with you?
Yes, he did.
Did he go over them essentially word for word with you?
Yes.
And do you understand it completely?
Yes, I do.
And did you sign the second page of that document?
I did, yes.
So you're telling the court you fully understand everything that's contained on this plea questionnaire as well as the jury instructions?
Yes.
You're pleading guilty to an OWI 7, 8, or 9. You're 58 years old. You have 11 years of schooling. You can read, write, and you understand the English language. No drugs, alcohol, or other medications in your last 24 hours. No treatment for a mental illness or disorder. All correct?
Yes.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney thoroughly go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on the plea questionnaire. Did your attorney thoroughly go over these rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over these rights with you in any more detail?
No.
So you understand them completely.
Yes.
Do you understand that by pleading guilty, you are waiving and giving up these rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you understand that the state would have to prove for operating a motor vehicle while under the influence 7th, 8th, or 9th offense on or around October 25th, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant? That is a Class F felony. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $25,000 or 12 years and 6 months of incarceration or both?
Yes.
And pardon me, Your Honor, but the record can reflect, as the court was reading it, a copy of the information reciting that count 1 is directly in front of the defendant.
Thank you, Mr. McLaughlin. So do you understand that there has been an agreement that's been recited on the record between you and the state as a recommendation for sentencing to the court? Do you understand that?
Yes.
Do you understand that I am not bound to follow that recommendation?
Yes.
Said differently, I could sentence you all the way to the maximum possible penalty if I find it warranted. Do you understand that?
Yes.
Do you also understand that with this crime, that there's a mandatory sentence that the court shall impose, a bifurcated sentence under Wisconsin law, with the confinement portion of that sentence being imposed on you for not less than 3 years? Do you understand that?
Yes.
So there's a minimum mandatory sentence of 3 years of initial confinement in prison, or a maximum of up to 12 and a half years. But that would only mean an additional 7.5 years of initial confinement. So 3 years mandatory, 7.5 initial, with 5 years of extended supervision. That's mandatory in the minute, and the mandatory minimum as well as the maximum. Do you understand that?
Yes.
Now, do you understand that if I thought it was warranted based upon the facts of this case, your history, all of the things taken together, that I should sentence you to a maximum possible penalty or any other sentence? Do you understand it's my decision to do so?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney?
I did. Yes.
In particular, that section that's called the probable cause section, where it basically says what happened and why you were charged with these crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty to an OWI 7, 8, or 9 because you are guilty of that offense?
Yes.
Mr. McLaughlin, did you thoroughly go over the facts alleged in the criminal complaint with the defendant?
Yes, Your Honor. I reviewed with the defendant the allegations that he, the arresting officer says that he pulled the defendant over because he was swerving in a public highway, deviating the center line, and that therefore, pursuant to Terry v. Ohio, there was a basis to stop, and that following his stopping the defendant for the reasons stated, there was more than sufficient indicia of odor of intoxicants, evidence of impaired appearance and as well as impaired driving. And in fairness to Mr. Ronning, he admitted that all of these facts were true. So therefore, Your Honor, pursuant to stipulation and review, there is more than sufficient factual basis within the narrative report to provide a basis for the charge as well as adjudication.
Thank you. Has anyone made any threats or any promises to you, Mr. Ronning, for you to plead guilty today?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he done a good job?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he discussed with you the evidence and the discovery in the case?
Yes.
Has he discussed with you any potential legal defenses or a lack of defenses in this case?
Yes.
And it's your decision to accept a plea and not proceed to trial. Is that correct?
Yes.
Are you satisfied with your attorney's services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
As to count 1, operating a motor vehicle while under the influence, 7, 8, or 9th offense, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed, will be dismissed and merged in with count 1. The judgment of conviction will be entered today. Argument, Mr. Schmidt.
Thank you. According to my ADA's notes, the court wanted to know Mr. Ronning's criminal history because he has connection to other states. And part of my argument for why the court should do the 3 and 3 out concurrent to Minnesota has to do with that. So I'll start with that. Mr. Ronning's criminal history shows he did 2 burglaries in the 80s, and then the rest of his history is drunk driving offenses and then various low-level misdemeanor offenses as follows. 1986, burglary, Wood County, Wisconsin. 1987, burglary, Douglas County, Wisconsin. 1996, disorderly conduct, Douglas County. 2002, Douglas County, operation after revocation. 2008, Douglas County, battery. Then in South Dakota, 1994, Yankton, drunk driving. 1994, Yankton, insufficient funds for a check in the third degree. 1995, Yankton simple assault. Minnesota, 2001, St. Louis drunk driving, 2003, St. Louis drunk driving, 2006, St. Louis drunk driving, 2011, Crow Wing drunk driving, 2016, Renville drunk driving, and now 2025, Olmsted drunk driving. So basically what his record shows is that from 2016 until our case, he had no drunk driving offenses, showing a 10-year period where he was staying clear of it. Then he got the drunk driving offense here, where because of the nature of his criminal history and driving record being multi-state and mostly old, law enforcement misread it and thought this was only an OWI 3, which is how he got released. 6 days later, after our incident date, is when he got arrested for drunk driving on that Olmsted one, which he's already been convicted of. He was sentenced on May 6th of this year for that Olmsted one. They sentenced him to 46 months with credit for 157 days. The sentencing order indicates the minimum term of imprisonment is 2/3 of the executed sentence, which I believe is, I used a calculator, about 32 months. There's like a fraction, a very small one after that. So I think if the court follows this agreement, the end result is his sentence is going to be a little longer, and it might affect his eligibility for programming through Minnesota. I think running it concurrent also enables Minnesota to send him back to Minnesota, and Minnesota shoulder the better programming. I think the criminal history reflects that he has a much stronger connection to Minnesota and a much more recent connection to Minnesota than here. I understand the sentencing memorandum shows that he has had connection to Wisconsin, but I think it's highly relevant that the vast majority of his convictions for drunk driving are Minnesota, almost all of them actually. So for those reasons, the state would ask that you follow the agreement. Thank you.
All right, thank you, Mr. McLaughlin.
My remarks are essentially consistent with Mr. Schmidt's, Your Honor. I think the primary point is that in my dealings with Mr. Ronning, he's fully accepted responsibility. He never disputed the charge of the facts. He waived his preliminary hearing. He's accepted responsibility. He admitted to me he was operating under the influence. I believe he faces, as I believe my client service specialist memorandum details, he faces significant incarceration and in Minnesota, plus supervision until 2033. So therefore, he is going to be under a long period of supervision in terms of community protection. I think the court wanted, and I referenced, and I made note of it, because I think the court wanted to know what Mr. Ronning's state of mind was. And I think my client service specialist does a good point in pointing out that his intrinsic motivation seems to want him to maintain and enhance his relationship with his daughter. He I think was frank with her, is that he has felt the weight of disappointment from his daughter in his behavior, and that at age 58, he has not only lost liberty, but he has lost life opportunity and damage to his important relationships. And perhaps better late than never, but that he is coming at this late age in life, that he appears ready to want to change his behaviors and regain the balance of his life in a positive fashion. We in the legal system tend to call that aging out of the system, but really I think it means it reflects a realization, either because of the pain of what you've inflicted on yourself and your family, that the punishment component of your conduct has set in, and that it is a external motivation to change. So, Your Honor, I think in terms of, I think Mr. Schmidt has, basically he has these period of non-OWI related offenses in the 90s, but then after that, essentially it's a period of simply drunk driving offenses. Not that they aren't serious, but there was a serious gap in terms of previous convictions until recent. So therefore, Your Honor, for these foregoing reasons, and under, of course, the court is well aware of McCleary v. State and Gallion, our seminal Wisconsin sentencing laws, that we use the least amount of incarceration consistent with the triad of the need to punish, his rehabilitative needs, and the seriousness of the offense. I believe the joint recommendation of the parties meet the McCleary and Gallion factors, Your Honor, when taken into consideration of the totality of his circumstances with his current Minnesota sentence. Therefore, Your Honor, for those reasons, I'd ask the court to please adopt the party's joint recommendation. I feel it is appropriate.
All right, thank you. Mr. Ronning, anything that you would like to add or you would like me to be aware of?
You state however you feel, Mr. Ronning. I did not prepare you. I just told you you have the last word.
Yes, you can say no, you don't have anything to let me
Or
know.
no, I think he does want to speak.
I just want to note that I'm looking forward to my 6-month intensive treatment program that I have arranged. And I also arranged to be released into sober living as well to help work with my program. And that's about it.
He previously mentioned to counsel, Your Honor, that there is a Minnesota intensive treatment program that he was motivated to try to obtain before he came over here, or came back here to be specific.
I think that would be great if you do engage in something like that. And I told you, and I fully believe your attorney.
Yes, ma'am.
We will go on the record in the matter 26 CF 65 State of Wisconsin versus Brian Belisle. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel, in person. Mr. Belisle appears by video conferencing with approval of the court. We're set here today in this matter for a preliminary hearing. Mr. Belisle, your attorney has filed a waiver of preliminary hearing document in the case file. Did he go over that document with you thoroughly?
Yes, Your Honor.
And that's your signature on the bottom of the document?
Yes, Your Honor.
And did you fully understand everything stated on that document?
I did, Your Honor.
Do you understand that once you give up your right, it's forever and you can't get it back?
I do, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, ma'am, Your Honor.
You're doing so freely, intelligently, and voluntarily?
Yes, ma'am.
I will find that you are competent, you're freely, intelligently, and voluntarily waiving the right to a preliminary hearing. The court will find probable cause and bind the matter over. Information, Mr. Vila.
Thank you, Your Honor. I filed the information. It mirrors the criminal complaint.
All right. Proceed with an arraignment or set it for another date.
Thank you, Your Honor. I'm comfortable proceeding with the arraignment today. I believe that as it mirrors the criminal complaint, that Mr. Belisle understands the charge here and the maximum penalties. We'll waive formal reading and enter in a plea of not guilty.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Is this something that is close to a resolution?
Actually, Your Honor, we have managed to reach a resolution in this matter for Mr. Belisle to plead to the sole count in the complaint as amended to a charge of obstruction, joint recommendation for costs. So we are prepared to schedule a plea and sentencing at the next available date.
Or if you want to handle it here today, Mr. Belisle, I could get it resolved today, but you're appearing by Zoom. So you would have to tell me that you want to waive your personal appearance being in person and have a plea by Zoom.
I would love that.
Mr. Feliski?
I have no objection to that. Then I'm comfortable proceeding as long as Mr. Belisle is.
All right.
I am. Thank you.
Mr. Belisle, how old are you?
I am 40 years old, ma'am.
Can you read, write, and you understand the English language?
I can, Your Honor.
Any drugs, alcohol, or medications in the last 24 hours?
No, ma'am.
Other than your AODA treatment, any other treatment for a mental illness or disorder?
No, ma'am.
Do you understand that you have the right to have a jury trial? You have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You have the right to testify on your own behalf or remain silent and not have your silence used against you. You also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights that you're giving up here today?
I understand.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
I understand.
You understand that here the state would have to prove that on or around April 17th, 2026, that while in the presence of an officer that whom you knew was an officer doing an act in an official capacity and with lawful authority, you failed to abide by the officer's demands or instructions, and or here you provided a false name. Is that accurate? Do you understand what the state would have to prove?
I understand.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 9 months of incarceration or both?
I understand.
You understand that there is a recommendation for costs only, but I'm not bound to follow that.
I understand.
I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand that?
I understand.
I also wanted to let you know that if you have any questions or concerns and you need to speak with your attorney during this process, let me know. I'll send them into Zoom and send you to a confidential breakout session, okay?
Okay.
Now, did you go over that criminal complaint with your attorney, that original charging document where it said what happened that day and why you were charged with the crime?
Yes.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty because you are guilty?
Yes.
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 Okay. Mr. Flisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty today, Mr. Belial?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily?
Yes, ma'am.
Has your attorney represented you competently?
Yes, he has.
Has he explained everything thoroughly to you?
Yes, he has.
Are you satisfied with his services?
I am.
Any questions for the court or for your attorney before I proceed?
No, I don't.
As to the amended count, will formal motion to amend?
So made.
Granted. As to the amended count of obstructing an officer, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. Mr. Belial is here present today taking responsibility for his actions. This isn't the most serious case in the world, given the facts that were presented here. Furthermore, it's my understanding that he is going to be on supervision even outside of this case. Given all those facts, I think this is a more than appropriate resolution. I would ask the court to follow it. Thank you.
Mr. Flisky.
Thank you, Your Honor. I concur with the remarks by the state. I'd also note that Mr. Belial entered into treatment essentially immediately after I began representing him. It sounds like that's something he'd been wanting to do for a while. He's currently at a follow-up program right now in Cameron, to my understanding. Part of the reason that we reached resolution here is that he does want to put this behind him. He wants to be sure to be able to access all the resources and programming that are available in his current location that he would not be able to do so otherwise with this open case. So overall, Your Honor, I do think this is an appropriate agreement. I think costs are an appropriate deterrent. I've asked the court to follow this agreement. Thank you.
All right, thank you. Mr. Belial, anything you want to state or add here today?
Other than I just want to resolve this and use the resources to better my life, better my chances at employment. I would like to ask, like, on the as far as a deadline on the fine payment, like like obviously I don't have a job or any means of funds right now. Could you be a little lenient on like a payment plan, or just give me a little bit of time to figure out a payment plan?
All right, thank you. Thank you, Mr. Belial. Mr. Belial, in looking at this case and reading the facts behind it, you did a stupid thing. I think
did.
Adrian's your brother. I can't recall if he is or what
Yes.
relation. Yeah, he's your brother.
Yeah.
You used his name, his ID to try and evade officers when I don't think there was anything to evade or obstruct.
Just the simple fact that I didn't want to go to jail, that was probably, a stupid decision. I realized that.
And that brings this case to a close. The judge made it clear that this wasn't just about one bad decision, it was about a repeated pattern that put innocent people at risk. The sentence may end the courtroom hearing, but the real question is whether he finally changes his behavior. What do you think? Was the judge right to go beyond the recommended sentence?